I expect you to have your next witness ready to go. I don't want there to be a 5-minute pause between one witness getting off the stand and the next witness getting on the stand.
No ex parte meetings.
The state knows, we're in the state's case right now. The state knows what it's doing. The state has investigative help. Make sure you have enough witnesses to carry us through each day and that they're ready to go. Again, that all just kind of falls under the auspices of let's be respectful of the jury's time.
I have a question, Your Honor.
Yes.
The court instructed that we provide the court with evidence for which there may be admissibility issues.
Yes.
I wanted to ask for the court's clarification if that meant whether there have been prior motions to suppress filed, or if the court is instructing that notwithstanding the absence of a motion to suppress on a particular piece of evidence, that we are now going to be entertaining motions to suppress. For instance, if there's a recording that we have turned over, will the court be entertaining motions to?
So I don't really know what the expectation has been. I mean, if this had been my trial from the get-go, we'd have litigated all the motions to suppress by now. Motions to suppress shouldn't really be getting filed mid-trial. That being said,
there were a lot of things that happened.
I would rather, if somebody is going to stand up and say this is 100% unconstitutional for X, Y, and Z reasons, I shouldn't be letting in something that's unconstitutional for X, Y, and Z reasons. So I'd like to know it, but I mean, I want it to be a legitimate, valid concern evidentially, constitutionally. I don't want it to be, you know, here's my chance to challenge everything under the sun. So I don't know if that answers your question, but
it's good stuff.
It sounds like there are chunks of evidence that everybody has just basically not gotten to yet. And y'all sort of said, all right, we'll get to that when we get to this witness. And if y'all have been operating on a kind of rolling, all right, when we get to this witness, we'll deal with that evidence, then I don't, if that's what the expectation is,
Love shaking her head,
then I wouldn't expect y'all to have
this lady is too funny,
filed
man.
all of your
Shout
challenges.
out to Miss Love.
I don't know what's been going on.
Your Honor, that has not been the case. No, but because of the way that the court indicated,
it hasn't. You sure
that the court wanted parties to provide evidence regarding admissibility issues? I just wanted to make certain that I understood what the court was instructing. There have been evidentiary issues that I believe the parties disagree on. The state disagrees with counsel for defendants' interpretation of what is ripe and what is valid for contesting at a particular moment. I don't doubt those will continue to arise, but I was asking as it pertains to what the court instructed just a second ago regarding evidence. I didn't know whether the court was doing something different than what I did.
Okay, so I don't intend to revisit rulings on evidence that's already come in.
Yep.
But for evidence that we know is out there and was going to be introduced a month from now with, witness Jones, if y'all been doing that on a rolling basis and y'all know that there are going to be evidentiary issues with it, things that I would have considered motions in limine, then I want us to all go ahead and voice that now.
Get it out the way.
Sort it out so that we know when the witness shows up what can be talked about and what can't be. And I don't know if that gave you clarification. Okay. All right, Ms. Abbasi.
Yes, Your Honor, if I may, I have to disagree with Ms. Love that it's been going along that we've already had motions about what is not admissible. Just to propound on kind of what Your Honor was mentioning and what the task of defense faces, we have a list of 8,000 jail calls. We haven't listened to 8,000 jail calls, and I think probably all the stories are not relevant. Everyone would agree that they're not relevant. The state not actually going to introduce all of those jail calls. However, defense, our burden, if we don't raise the objection, it's been waived, and then it comes in at trial.
Okay, so that's why the witness lists with what this is relevant to and what evidence is going to be used is going to be, I hope, very helpful in giving us all a better kind of groundwork.
Yes, Your Honor, that is precisely what I'm asking.
Okay.
20,000 pages of Instagram, it's going to be these ones.
Okay.
And Jeff,
Yes, sir, Mr. Adams.
good
Yes,
afternoon. Again, Jeff
8,000
Keith
jail
Adams
calls.
with Mr. Steele for Mr. Williams. Just to, I think the court wanted to know if there are things that Judge Glanville had been doing in regards to that particular issue. And I did want to just append to what Mr. Bond was saying. For example, there have been jail calls, there are interviews that generally speaking there have been hearings on the admissibility of those statements.
Okay.
But the court has oftentimes
This
said,
case is going to take forever.
I agree that, for example, this statement may be admissible, but there may be some things in the statement that's objectionable.
Sure.
We'll deal with that
Okay.
at that time. The court has routinely been doing that. So not necessarily kicking the can down the road, but addressing issues as they come up. And the court has urged both sides in advance of that issue coming up. If we can get together and iron some things out, let's do it. We've been working to do that, but there have been routinely times where we simply just disagree and we've had to take those items up. And I think what you would like, what Judge Landell has asked, is that let's let you know about it as far in advance as we can. And that way you can set aside some time to deal with it without impinging on the juries.
Absolutely. I mean, that is, I want to be respectful and cognizant of the jury's time. I also want y'all to all know what to expect to the extent you can. And
sounds like she's telling them to work together.
that we can litigate beforehand, if it's going to be necessary. Now, if there's some totally irrelevant Instagram post and the state knows they're not going to use it, but they listed it a million years ago, their updated list that they're going to share with everybody should not include the Instagram post that they know they're not going to use. So, all right. So I will expect whatever filings y'all, I will anxiously anticipate all of them. Make sure whenever you file anything that you contemporaneously email a copy of it to Ms. Rosser, because the court and chambers do not automatically get what y'all file. I have no idea what you filed unless you actually let us know. So make sure that when you file it, you send a copy to Ms. Rosser so that we know about it. Okay? All right, so I'll plan to see everybody bright and early at 8:45 on Tuesday, July 30th. All right?
July 30th.
Don't leave until you make sure Ms. Rosser has your cell information.
Contemporaneously.
Yes.
Judge Glanville had, for both sides, 2 Fridays before that tell the other side what witnesses and what exhibits are going to be in play. I would hope that continues. That was very helpful.
That sounds like a good idea. So sure, we can leave that as sort of a standing rule. And I suspect that this is true as well, but let me go ahead and say that as we're going through trial, I expect you to have your next witness ready to go. I don't want there to be a 5-minute pause between one witness getting off the stand and the next witness getting on the stand.
No ex parte meetings.
The state knows, we're in the state's case right now. The state knows what it's doing. The
No
state
talking
has
to
investigative help. Make
people
sure
in their
you have
car.
enough witnesses to carry us through each day and that they're ready to go. Again, that all just kind of falls under the auspices of let's be respectful of the jury's time. Mr. Harvey.
Can I assume, Judge, that we are going to continue with the opt-out rule so that you're not going to get all 8 of us standing up going, I'm in too.
Yes, no, that's a great idea. Let's continue with that rule as well.
Thank you.
I mean, I plan to basically continue with the rules already in effect unless there's some reason to change them. So I hope if there is something, y'all can bring it to my attention. Otherwise, we'll just keep rocking as before. All right, thanks everybody.
To be honest, remember the press.
She is not playing around.
Place for the members of the prosecutor to witness this on Friday, so if someone will be excluded to be shown on camera, I want to make sure that's still in place as well.
Okay, so I guess y'all would have agreed beforehand that a particular witness shouldn't be shown on camera, and then who gave the list?
The state has been providing to members of the press the list of those persons, and the judge has made rulings regarding those.
So I saw a ruling that said if there's somebody who, for whatever reason, shouldn't be shown, whatever kind of concerns, then they won't be shown in the, but
It wasn't exhaustive.
it seemed that was kind of a witness by witness thing, and that there was an opportunity for input.
Yeah, there's an order that the judge entered, and there were certain reasons that the state could request that witnesses not be televised.
Still waiting on a motion for Mr. Weinstein too.
The Friday before, and then we would have the opportunity to object to that by Monday.
Right.
And then the judge would make a decision based on his criteria, whether that witness should be shown on television or not.
Right.
And I believe that Mr. Harvey has a standing objection to all witnesses at this point.
Okay. Wait. To all witnesses being shown or being excluded? Okay. Well,
Look at Miss Love. Oh, man. We need to make that into a meme.
Okay. Well, that's why I guess it's being taken up on.
And I'm in concurrence with this.
Oh, Miss Love is done. Look at her. She's having a full-on conversation with herself. She is done. Oh my gosh. And listen, I want to be fair too. And I think we should take this time, to give the prosecution a fresh start. Maybe they can redeem themselves now that there's somebody who's unbiased. But look at Miss Love, man. She's out. She's having a whole full-on conversation with herself. Y'all can hear her saying that I want, and then this. Look at her. She's mad.
Wait. To all witnesses being shown or being excluded? Okay. Well.
No witnesses excluded. I don't want to speak for Mr. Harvey.
All right.
And I'm in concurrence with this.
Okay. Well, that's why I guess it's being taken up on a witness by witness basis. So, Ms. Love, then you're providing that to the court and the opposing counsel. If there's objection, we're litigating it. And then are we saying it's like the next Friday that we then tell the press? Or help me out on that.
Ms. Hilton says she has been providing that list. I will let her explain to the court.